Hey, welcome to today's video. I'm Richard Chapo. I'm an internet lawyer in San Diego, California. And today we're talking about consumer rights under the CCPA. So the CCPA is the California Consumer Privacy Act. It is a new privacy law in California that goes into effect January 1st, 2020. Now, if you are a business located outside of California, the important thing you need to know is that if you are collecting personal information from California consumers, you may well need to comply with the law regardless of your location. There is a threshold provision, but it's very low. So you're going to want to talk to your attorney about that. Now, the CCPA is a bit of a revolutionary law in the U.S. because it incorporates quite a few modern privacy law requirements that we don't otherwise see in the United States. These are requirements coming out of other countries such as Canada, Europe, and even some out of South America. Now, the basic idea of the CCPA is to try to create a more transparent environment regarding data collection and usage practices, and give consumers not only the ability to kind of understand more specifically what's being done with their information, but also give them some rights as to how that information is used. CCPA has often been referred to as sort of a light version of the GDPR. It's not nearly as complex or restrictive as the GDPR and incorporates quite a few different concepts. But generally it's that big of a revolution in privacy law. We don't have a general privacy law in the United States. And so, most companies here, if you're not GDPR compliant, this law and the compliance is going to be a shock. And it goes into effect January 1st, 2020. So if you have not started compliance yet, or you have questions, you need to deal with them now. So let's look at the consumer rights. So the right to notice. So what this is basically saying is the days of the short 500-word vague privacy policy are over. You're going to have real privacy policies so that when somebody reads them, they're going to have a very good idea of what information is collected, what categories, why the information is collected, the categories of third parties it's shared with, so on and so forth. And again, we're talking about real transparency here. Something where if you read the privacy policy, you're going to understand what's happening with your data. And then there are additional rights that you can exercise. And so let's talk about the right to access. So I've actually kind of powered in a bunch of different rights under this heading. But the right to access is sort of what you would think. A person's going to have the right to request what data you have on them and to see it all, see the categories, see what the purpose of the data is. What are you using it for? Who are you sharing it with? And those kinds of things, so that they know specifically, what you're up to. And then on top of that, there's going to be a right of deletion. And so the right of deletion is going to give them, as the name suggests, the right to delete certain information. So one of the concepts, or one of the problems that we've run into with the web as it's evolved over time is, as a commercial medium, we're now about 20, 25 years into, the web's growth, and people have some data online from many years ago that maybe seemed like a good idea at the time, but now does not. So let's give you an example. Let's say when you were 18, you were at a party, you were the king of the beer bong, and somebody took a picture of you, and it is online. It was posted on Facebook or who knows, somewhere, and it's online. Well, now it's 10 years later, and you're applying for real jobs with real employers and trying to have a career. And the thing those employers are going to do is do a Google search for your name as part of their due diligence. And then they're going to click Google Images. And if one of the images that pops up is you gunning a 6-pack through a beer bong, well, that's probably not going to be good for your job prospects. And so one of the issues that has been discussed at length in the internet law field for a number of years is, how long are we going to punish people for these things? Because believe it or not, lawyers were also people at one point, and we also may have tried the beer bong. And so this idea really started to ferment in Europe first, where they started to allow a right to delete or a right to erase, called it different things, but people could go in and delete this type of information. And the CCPA incorporates this. So you're going to need to have procedures and processes in place so that you can process these requests and actually delete the content. Now, there are going to be exceptions to the right to delete. That kind of goes beyond the scope of this video, but make sure you talk to your attorney. Obviously, if it's some kind of information that's at the heart of a legal battle, or somebody posts child pornography or something of that sort, and you call the police, they don't have a right to delete that. They're not going to delete evidence. But the general idea is there is going to be a form of right of deletion. Our next one is the opt-out of sale of personal information. So a person could come to the site and say, hey, what kind of information do you have on me? They look at it and they say, whoa, I don't want this information up, or I don't want this information shared with other parties. So I'm going to opt out of sale. And in fact, you're going to have a link on your website or app that says, do not sell my personal information. And when the person clicks that link, they're going to go to a page where they can either submit an email or fill out a form or whatever, telling you, I'm opting out of the sale of personal information. Now, most of you watching this, particularly if you're smaller, maybe a 1 or 2 or 3 man operation, you have a website or an app, are probably thinking, no big deal. I don't sell personal information anyway, so this doesn't affect me. Au contraire. And this is where the CCPA starts to become problematic, and it has to do with definitions. So personal information under the CCPA is, it's not just name and email address and street address and phone number and that kind of thing. It's extremely broad. The definition is so broad that it includes things like olfactory data, meaning information on things you smell, your smelling senses, facial recognition data, IP addresses, geolocation. It's extremely broad. It's difficult to think of things that it doesn't include. And so the sale, when they say sale of personal information, well, just keep in mind personal information is extraordinarily broad. And on top of it, the definition of the word sale is also very broad. And it raises all kinds of interesting questions that lawyers are going to spend years arguing about and possibly making a good bit of money on. So let me just give you the definition. Selling, sale or sold means selling. Now, isn't that funny? They just defined the word selling by saying it means selling. But anyways, unfortunately, they added more information. So selling, sale, or sold means selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means a consumer's personal information by the business to another business or a third party for monetary or other valuable consideration. So the problem that we have here, of course, is when you tell me that you're going to sell something to somebody else, I think you're going to give them something in exchange for typically money. And when we look at this definition, that's obviously not the case. While that transaction would be covered, it also applies to a situation where you are disclosing, disseminating, releasing, making available, or otherwise communicating the personal information of a consumer to a third party. Now, you might be thinking, okay, but it said for monetary or other valuable consideration, and you're absolutely right. So monetary is obviously a situation where there's an exchange of money, but other valuable consideration, okay, that phrase is not defined in the CCPA, and the word consideration has a particular legal meaning. It means essentially anything of value coming back the other way. And so the problem that we run into here is when we start thinking about websites and the way a lot of them work, it's very rare to find a website that is wholly isolated. So typically most websites, you can think of the WordPress, platform, for instance, you're going to have third-party interactions. So you might have a website built on WordPress platform, and you're going to have plugins for third-party mail services like MailChimp. You may add code for things like an analytics program like Google Analytics. You're going to have third-party social buttons on there and things of that sort. Well, with each of those services, are you disclosing or making available or transferring personal information of consumers to those third parties? Arguably, you are. An IP address is considered personal information. So when somebody comes to your site, your servers are collecting personal information. And if you have code on there that's going to allow, let's say, Facebook through the like button, to track that person, to say, okay, here's, I'm identifying this person. And if they click the like button, I'll know which IP click the like button is coming to Facebook. Well, is that, making available, transferring, or sharing that information? I would say yes. There's going to be a lot of litigation over that issue. And there you have it. But what about for valuable consideration? Okay, well, Valuable consideration depends how we define it. So if that Facebook like button, the person presses the like button, are you getting valuable consideration? And I would argue, yes, you are. Why? Because your information is being shared with Facebook. That post is either going to be, depending on how the like or the share, what button they're clicking, but you're either going to have information on Google that's going to get an up ranking, that's going to make it more attractive to people, or you may have the entire post shared on Facebook in some cases. And if it's shared on Facebook, you're being exposed to a new audience. And isn't that free publicity? Isn't that valuable consideration? So you can see how we go down the rabbit hole here. And there needs to be a thought process for each and every third-party provider that you're dealing with on your site. And so it becomes a very complex situation, and you really need to sit down and figure out, what your process is going to be and what your policy is going to be with each of these third providers to try to put together some kind of an organization, so that if the California Attorney General, starts contacting you and saying, hey, are you selling information, despite somebody, wishing to be opting out of this, you have some basis for responding to that. And so it quickly becomes a bit confusing, as you can imagine and certainly see. Now, it only gets more interesting. We have a right to opt in provision. And what this is it's dealing with people who are under 16, so teens and children. And it breaks it into two categories. The first is 13 to 16. And what the CCPA dictates is that you cannot collect personal information. Remember how broad that definition is. Personal information from children under 16 online or off, unless they opt in to allow you to do that. So essentially, unless they affirmatively consent. And so this raises all kinds of issues, as you might imagine. Let's say you have a forum devoted to the video game Fortnite. Okay. How many people on your forum, let's say it's popular, how many people on your forum are 17? How many are 15? How are you going to identify those individuals who are 15? And how are you going to get their consent? You're going to have to build some kind of an opt-in provision. If you think that's bad, think about Facebook. How are they going to identify a 15-year-old versus a 17-year-old? There are billions of people that have opened accounts with Facebook. What about Instagram? What about YouTube? What about, you pick your favorite site. This is going to be a huge tactical problem. And so we're going to have to see how that's dealt with. But if you run a site, devoted to the finer points of dentures, you probably don't need to worry about this. But if you are running a forum about, the Legend of Zelda or something of that sort, it's going to be a problem. Now, there's a second category of the right to opt in, and that is for kids that are under 13. And in that situation, you're also going to need affirmative consent. However, the CCPA says that you don't get it from the individual in charge. You have to get it from their parents or from the legal guardian of the person under 13. Personally, I'm not too worried about this provision because there's a federal law known as the Children's Online Privacy Protection Act that addresses the collection of information from kids under 13. And where we have a federal law and a state law that cover the same topic, the federal law trumps the state law, no pun intended, and the state law is more or less void. So I don't think we're going to see much action on the under 13 provision of the CCPA. Frankly, it's probably dead on arrival. But it also probably gives you some insight into the California legislature that they would still include that language. And so basically that's the opt-in right. So again, this is another area you got to sit down with a lawyer and figure it out. Now the final right that we're going to discuss, and again, this is a general discussion of these rights. There are actually subsections of these rights that you need to be dealing with. Again, talk to your lawyer, but it's important to understand at least the general concepts. We have the anti-discrimination clause in the CCPA. So you're thinking age, race, gender, and what have you, and that's actually not what we're talking about here. Anti-discrimination under the CCPA means that you cannot discriminate. Easy for me to say, you cannot discriminate against somebody who exercises their consumer rights under the CCPA. So if I show up on the site and I say, I want all my information, and I've posted 30,000 times to your site, and you have to go out and spend all this time and effort, putting it all together and getting it all to me, you can't just say, you know what, we're terminating you from the site. Or you can't start charging me more than you're charging the other, parties on the site. or you can't limit my access to certain aspects of the site. You can't even give me the virtual middle finger. You have to treat me the same as anybody else. So that's what we're talking about with the anti-discrimination provisions here. For most small sites, probably not a big issue, but it's something that you want to keep in mind. Now, there is an add-on to this. I just want to mention it's not an actual consumer right, but I've already had some questions about this. And so let me just clarify. You cannot contractually limit these rights in your terms and conditions, terms of service, terms of use, whatever you want to call them. There have been efforts in the past on some websites to say, that you cannot exercise certain rights legally if you agree to these terms and conditions. And we see it right now with a lot of websites with mandatory arbitration provisions. And what those provisions are saying is the person using the site is waiving their right to a trial. And they instead have to go to arbitration. And the reason for that is arbitration tends to be more business friendly than juries are. Arbitrations tend to be heard by retired judges and attorneys, not juries. And so businesses get more favorable judgments. And even when there's a judgment against them, it tends to be for much lower amounts. You cannot do that under the CCPA. There's actual language saying that any effort to do that will be void. So, unfortunately, you're going to have to comply with all these rights. Now, the actual privacy policy that you put together, it's going to be a pain in the rear. But what really is the key here is putting together policies and procedures to deal with each of these rights. So when a consumer exercises the right, you can handle it. And you don't want to do that for the first time when somebody has made a request. You want to be able to, have your systems in place so you can go ahead and take care of it. And that's the big important point. So anyways, that's it for consumer rights under the CCPA. If you have any questions or comments, feel free to contact me at SoCal Internet Lawyer, or if you need help with the CCPA, you can also post comments below. Please don't post anything that is sensitive or confidential. There's no attorney-client privilege that applies to the comments below. They are available to the public. If you enjoyed the video, consider giving it a thumbs up. Otherwise, you might subscribe to the channel. We'll be posting all kinds of videos on the CCPA. And otherwise, thanks for watching. Have a good one.